Welcome to Resilience and Resolve with Lance Drury.
Welcome back to Resilience and Resolve. We're tackling a sensitive question. Can tax debt be eliminated through bankruptcy? I'm ever back here with Lance Drury, and we'll break down the rules, exceptions, and timings. How you doing all the way in Nashville, Lance?
I'm doing great. Had a great drive yesterday all the way to Nashville. Lots of traffic, though, but it was Father's Day, so I'm sure there were a lot of people on the road.
Absolutely. Let's get down to it. So right off the bat, can tax debt ever be wiped out through bankruptcy?
There can be, but there's only one type of tax generally that's subject to that. You cannot get payroll tax discharged in bankruptcy. You can't get trust fund discharged in bankruptcy, but under certain circumstances, you can have your personal income tax discharged in bankruptcy. The tax has to be more than 3 years old. It has to be on file for X number of days. I can't remember if the return had to be filed at least 240 days before that to happen. So there are some specific rules. The biggest is the tax has to be more than 3 years old. So if you've had 10 years where you haven't paid your taxes to Uncle Sam, you can get a lot of that discharged, but not all of it you're going to get discharged in bankruptcy.
Does it matter? I know does which any chapter matter? You know how you file, or is it bankruptcy in this case?
No, you got to file Chapter 7 bankruptcy for the discharge. You can also at times get a payment plan under Chapter 13 for back taxes. And sometimes the bankruptcy trustees will be more generous than if you go through the normal IRS process. You may have to pay less because there are certain types of expenses that I think a bankruptcy type judge would accept that the IRS probably wouldn't. There's limitations on some expenses with the IRS. I referred somebody to bankruptcy not too long ago, but it wasn't successful. So now they've hired me for a resolution to get rid of their tax burden and to get them set up on a plan that they can afford to live with.
What about time requirements? Do they make certain tax debt eligible for discharge? Does that matter at all?
Yeah, it has to be more than 3 years old, like I said.
Mm-hmm.
So if you've got, let's say, income tax debt, it's now 2025. So 2021 would be eligible if you filed now because that would have been due in April of 22. And I've got to tell you, here's what you have to watch out on. I had a guy several years ago now, and he went to a bankruptcy attorney, and they filed in bankruptcy court, and they got some of it discharged, but 250,000 they did not get discharged because he asked for an extension on the filing of his return from April till October. They file in September, a month before the 3 years was up, and the guy lost out on $250,000, had to hire me to get him a resolution because they had filed too early. Now, he claims he told them, but I don't know if they brought it up or not, but they should have at least inquired and found out, well, did you ask for an extension? Or they should have gotten a power of attorney from the IRS so they could go in and verify all this before they filed the petition in bankruptcy. So there's a lot of bankruptcy attorneys, and they're very good at what they do, but they don't know a lot about the dischargeability of taxes in bankruptcy. A lot of them just tell their clients, you can never get taxes discharged in bankruptcy, which is not true, but it is limited. It is limited. Like I said, you'll never get payroll tax discharged. You'll never get trust fund civil penalty discharged. You can't get state sales tax discharged in bankruptcy, but you can get your personal income tax discharged under certain limited circumstances.
What about does filing bankruptcy pause IRS collection or their efforts automatically, or is there a different process with that?
Oh, no. When you're in bankruptcy, it stops the running of the clock on collections. So there's going to be a pause in running out the clock on collections if you file bankruptcy. That's one of the reasons why, everybody says, oh, it's 10 years from the date the tax was assessed. Well, it is, except there's so many things that can stop the running of the statute on collections that for each tax liability period, we have to go in and calculate when that last date is, because it's very seldom just 10 years. Collection due process hearing stops the running of the statute of collection. Bankruptcy stops the running. Certain types of appeals stop the running of the statute. Stops the running of the statute on collections. So we have to calculate for each year what that year is. And guess what? We sometimes have problems with the IRS over when the clock expires. We got one now. We think it ran out already. The IRS doesn't think it runs out until 2031. How they came up with that calculation, I don't know. But we're talking $200,000 in tax liability. So I've got one of my attorneys fighting on that now, but it could be another 6 months. Wow. Because the IRS is slower now than I've ever seen it. In fact, I was just talking to one of my attorneys here in Nashville earlier this morning. He has a case in U.S. tax court that's been there since 2022. And the reason is, and this has happened a lot now, they're switching their appeals officers. I just had an equivalency hearing. We had three times set for the equivalency hearing because they kept changing the appeals officer who was going to conduct the hearing, which was fine with me because my guy owes about $90,000. And guess what? The gig is up in September. The IRS will no longer be able to collect the tax. So there's no way in 3 months or less that the IRS is going to be able to collect much money on that guy.
So why don't people just do this then? Do the bankruptcy thing. What's the downside? Why doesn't anybody just do this to kind of get out of their problems?
Well, because it's only good for income tax. Mm-hmm. And like I said, sometimes you refer people there, but they, for whatever reason, it doesn't work out. But generally, if it's more than 3 years old, you can get the income tax discharged in bankruptcy, but you had to have the return on file for X amount of days. You can't have any fraud. You're not going to get anything discharged in bankruptcy if it was somehow fraudulent on your part. But it's a recommendation. It's an avenue that people can utilize to get their taxes discharged in bankruptcy under certain conditions.
So what risks do people face if they file bankruptcy without some input from a Lance Drury?
Well, the problem is they're not going to know whether or not they're eligible for the discharge in bankruptcy. That's one of the things that we find out when we sit down and do our tax account analysis. We figure out, okay, are these taxes eligible to be discharged in bankruptcy? And we'll let the client know if necessary, and then they can decide. But you've got to do your homework before you can decide whether or not that bankruptcy is a viable alternative for your client. Now, like we said earlier, the downside is the clock stops on collections. So if you got somebody where the clock's going to run out on collections in 6 months to a year, you might want to think twice about filing for bankruptcy.
Is that something you would suggest to a client, though? If let's say they came in and they didn't know what they would do, is that something you would present to them, or would you have a different suggestion? How would that even come up? Or is it something that you would wait for them to kind of broach the subject on, or you would just kind of talk?
No, we would talk to them about it if we thought that it was a viable alternative. But again, we have to go through and make sure. You can't always tell in the initial consult if they're going to be a good candidate or not. We have to do our own independent investigation. And here's why. 50% of the time we talk to people during the initial consult, and 50% of them have their situation absolutely correct, 100% correct. But the other half of the time, they know something that's going on with their case, but they don't know all of it because the IRS makes this so confusing, so complicated, that the average individual doesn't always know what their situation is. For example, they think they filed all their tax returns. Well, we go in, we find out, well, no, they're not. Now, they may have filed them, but guess what? Then I asked, did you send them in by certified mail? No, I didn't do that. Well, the post office could have lost it. The IRS could have lost it. And as I think I've said before, when the pandemic went on, they had 5 million tax returns sitting outside their facility when they came back to work after a couple months. Well, I don't have much doubt that some of those employees were so frustrated with the amount of the returns, they probably intentionally destroyed some of those returns. So, you got to do your homework first. And so a lot of times we don't know what the answer is in the initial consult because we have to go in and see what's going on with the IRS. And that's one of the things that people, tax returns, their liability. Some people come and say, oh, I owe $30,000. Oh, no, it's 70, it's 80. Or they get the returns prepared and filed and they say, oh, my liability's $70,000. And I said, oh, no, it's not. We haven't even begun to talk about penalties and interest. And the biggest penalty, if they haven't filed for years, the failure to file penalty is 5% a month of the raw tax for the first 5 months that it's late. It maxes out at 25%. So if you got 70,000 in tax liability, you're talking about 17,500 just in the failure to file penalty. And we haven't even begun to talk about failure to pay penalties or interest.
Can you, for sidebar question, can you explain to the people what the importance of certified mail is in these kind of cases when you're dealing with tax and you're dealing with tax resolution? Why would that certified mail kind of be beneficial as opposed to just sending it regular in the mail? Why should they go that extra step?
Because you don't have any proof then that the IRS accepted it, and you can track it then because the only part of the government that's as bad as the IRS now is the post office. And so the post office loses stuff. I've never seen the Postal Service as bad as it is now, and that's been since the pandemic. And in fact, I had a gentleman mail me a huge check from Illinois about an hour or so from my Ste Genevieve office. It took more than a month to get there. I've had other clients, the checks were returned because the post office destroyed the checks. So you better send, and it's very expensive for us to send certified mail. But guess what? We do it for anything that's important because if we don't have the proof that the IRS accepted it, guess who's going to win that argument? It's not going to be the taxpayer.
So when should someone consider bankruptcy as a part of their tax resolution strategy? I know we touched on a few things, but when should they do that? When would you advise them to do that?
When there's a lot of tax liability that's several years old and they have not recently filed the returns. If they've recently filed the returns, it doesn't matter what tax period it was, because those tax returns have to be on file for a certain period of time. Under those circumstances, bankruptcy might be a good option, but they need to talk to a bankruptcy attorney about that. And we refer them to bankruptcy attorneys from time to time.
Do you feel when do you feel that is when it maybe is more extra complicated, or just is it case by case?
No, when it's old enough that they could get that discharged in bankruptcy. The one problem though is if they do a Chapter 13, they could end up paying that bankruptcy attorney more than they pay us to get set up on a payment plan, because those Chapter 13 payment plans take years and years. And so the bankruptcy is open all that time. So they got to be paying that lawyer during their time. So it may not be monetarily feasible to get set up on a payment plan in bankruptcy court. But certainly it would be if you're going to get it completely discharged, because those Chapter 7 cases take a lot less time than a Chapter 13 case.
Lance Drury, sir, I appreciate your time as always.
Well, happy to be here again, Evan. But in a new venue, Nashville.
In a new venue. I know we got a different backdrop, different state.
And I'm even wearing a suit today.
Oh man, I see you. I said you suited and booted, got the tie on. I was like, "What's going on, Lance? What's this special occasion? Where you going after this?"
Well, I'm going to have people in the office today, so.
Thank you all for joining us. Bankruptcy isn't a quick fix, but it can be part of a broader strategy. Visit lancedrurylaw.com to explore your options. Thank you all for watching.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.